What's that? We don't have a motion to dismiss in the amended rules of civil procedure? Are you sure? Okay, let's find out. Hello and welcome to another lecture video, and in this video I will talk about the motion to dismiss. If you have been following the amendments to the rules of civil procedure, you will notice a very ostensible and significant change, and that is on the motion to dismiss. So I call this video "Whatever Happened to the Motion to Dismiss?" And to that question, my quick answer is it's not what you think. So let me explain. So first, a review. What is a motion to dismiss? A motion to dismiss is a legal pleading that asks a court to decide a case in favor of the pleading party because no legal claim exists, even if the facts are true as stated by the plaintiff. The motion to dismiss is used by defending parties who are trying to have the case thrown out in the early stages of litigation. Now, it's good if the motion to dismiss is granted because the case will be dismissed. Bravo for the defendant. But if the motion to dismiss is denied by the court, the Supreme Court has held that the order of the trial court denying a motion to dismiss is merely interlocutory, as it neither terminates nor finally disposes of a case and still leaves something to be done by the court before a case is finally decided on the merits. Therefore, the proper remedy in such a case is to appeal before a decision after a decision has been rendered. In other words, once a motion to dismiss is denied, the defendant has to file an answer and just to proceed with trial and wait for the decision or the judgment in the case and raise the same arguments in the motion to dismiss as may be grounds for appeal. So some would say, a motion to dismiss would seem to be useless because if it's denied, you can't even appeal it. And so others would remark that a motion to dismiss is a delaying tactic for the defendant to prevent or stall the conduct of the trial. So with those observations, should we get rid of the motion to dismiss? Well, we are talking about the amendments. And these amendments, the 2019 proposed amendments to the 1997 Rules of Procedure, amended Rules 6 to 35 of the Rules of Civil Procedure. And they came to effect last May 1, 2020. And going through these amendments, you will notice this. Rule 16, motion to dismiss, is no longer there. And it is merely stated that the provisions are either deleted or transposed. Okay, so as the rules stand, you have Rule 15 and then Rule 17. There is no Rule 16. So what happened to the motion to dismiss? Well, the motion to dismiss is still recognized under the amended rules, particularly Section 5, Rule 15, and Section 12, Rule 15. Rule 15, by the way, is the rule on motions. So Section 5, Rule 15 provides the litigious motions, and litigious motions include a motion to dismiss. Now, under Section 12, Rule 15, you have the prohibited motions, and the following motions shall not be allowed. Accordingly, motion to dismiss is not allowed except on the following grounds. So in other words, if the motion to dismiss is not grounded on these three, then it will be denied outright. So choose your grounds wisely. So what are these exclusive grounds allowed for a motion to dismiss under the amended rules? Well, number one, that the court has no jurisdiction over the subject matter of the claim. So as you lawyers may well know, that a court's jurisdiction is conferred by the Constitution or by law. So it cannot be decided by the parties, or it is not subject to stipulation. So if the court has no jurisdiction over the claim, over the prayer, over the subject matter, then a motion to dismiss is proper. Also, another ground is that there is another action pending between the same parties for the same cause. And this is what we call litis pendentia. In other words, pending litigation. So the policy is that no two courts shall resolve the same case involving the same parties, involving the same causes of action, involving the same reliefs, because of the possibility of conflicting decisions. And the practice of filing several cases in several courts is forum shopping. So forum shopping is, of course, prohibited, and so any act of forum shopping should be brought to the attention of the court, and so that is a ground for dismissing the case. Now, the third ground is that the cause of action is barred by a prior judgment or by the statute of limitations. Now, this ground is actually composed of two grounds. So, first is res judicata, and the other one is prescription. So, res judicata simply means conclusiveness of judgment. So what has been decided in the past with finality can no longer be tried again. Now, for prescription, well, this only means that the claim is extinguished by the passage of time. Okay, so these are the three exclusive grounds for a motion to dismiss under the amended rules. So what happened to the other grounds recognized under the old Rule 16? And I am referring to the following. So that the court has no jurisdiction over the person of the defending party, that venue is improperly laid, that the plaintiff has no legal capacity to sue, that the pleading asserting the claim states no cause of action, and that a condition precedent for filing the claim has not been complied with. These grounds have been used in the past, and they have succeeded, in having the cases dismissed. But then they're no longer recognized as grounds for a motion to dismiss under the amended rules. So what happened to them? Well, they are not entirely lost, because under the amended rules, they may only be raised as affirmative defenses in the answer. But there's a caveat. Failure to raise them as affirmative defenses at the earliest opportunity shall constitute a waiver thereof. So when preparing the answer, the lawyer should be aware and conscious of these grounds. And if facts are present to support any of these grounds, then the same should be argued in the answer as affirmative defenses. Otherwise, they are lost forever. Okay, so when allowed, meaning to say when the motion to dismiss is proper under the amended rules, so how do you deal with this motion to dismiss? Well, first, because it is a litigious motion, movant must serve a copy to the other party, either personally, by private courier, by registered mail, or by electronic means. Now, the opposing party has 5 days from receipt within which to file a comment or opposition. So here, the period has been fixed by the rules. Instead of the opposing party asking for a period from, let's say, 5 days to as long as 20 days, subject to the discretion of the court, okay, the period is already fixed. Now, the court, in its discretion, may call for a hearing on the motion. Now, this is important. In fact, this changes everything. Because before, a motion to dismiss should be set for hearing by the movant. At the end of the motion, there must be a notice of hearing. And the Supreme Court has invariably held that the failure to set the motion for hearing is fatal to the motion to dismiss. But now, it appears that the defendant is no longer required to set the motion for hearing. Just furnish the opposing party and then file it in court. Because after the receipt of the opposition, the court will determine if there is a need for a hearing. So clearly, it is the discretion of the court whether to set the motion for hearing or not. Okay, now finally, the court shall resolve the motion within 15 days from receipt of the opposition or from the expiration of the period to file said opposition. So clearly, the Supreme Court wanted to abbreviate and shorten the resolution of the motion to dismiss. So the motion to dismiss is still recognized, provided that when you are the movant, you follow all this procedure. So under the amended rules, the defendant can do either of the following to throw out the case in the early stages of litigation. So first, the defendant may raise affirmative defenses in the answer using the grounds for a motion to dismiss or those grounds which I mentioned, which are now good only for the answer as affirmative defenses. Now, also, the defendant may file a motion to dismiss based on the exceptional grounds, the three grounds which we mentioned earlier. Either way, if meritorious, the case may be dismissed by the court with prejudice. Okay, so clearly, the motion to dismiss is not totally lost to the defendant. The grounds are just minimized and are specified, while the others are placed as grounds for an affirmative defense in the answer. Okay, so that's where, or that's how, the motion to dismiss has ended up after the amendments to the rules of civil procedure. So I hope this was helpful to you, and thank you for watching.